Justice Kavanaugh?
Just to start, I am concerned, as you said, that the combination of campaign finance laws and this court's decisions over the years have together reduced the power of political parties as compared to outside groups with negative effects on our constitutional democracy. So I start from that, and I'm trying to figure out how this case fits into that with respect to political parties and the strength of political parties. On the other hand, I'm also concerned, of course, about quid pro quo corruption and the circumvention concerns. And one of the things that I think you rely on pretty heavily are the earmarking rules to prevent the circumvention in this case. Now, the other side and a lot of the amici say the earmarking rules are really pretty toothless in practice and really don't do much, and this picks up on some of Justice Kagan's concerns as well. They reach only the most clumsy efforts to pass contributions to candidates. It's difficult to police. Donors rarely need to explicitly earmark to accomplish their goals. So if earmarking's a key to the quid pro quo corruption piece of this, how can we be sure that those are actually going to do much in the real world?
Sure, and what I would say is earmarking is one part of it, and violating the earmarking rules is, I believe, a crime. But I think it's important to understand where it fits within the mosaic and why there are multiple prophylaxes here that are aimed at preventing the type of quid pro quo corruption at issue here. I start out with the fact that the money has to actually go through the political party. So the donor who's trying to bribe a single candidate has to go through the party who's trying to get elected lots of candidates and hope that the party spends that money on behalf of the candidate that the donor is trying to bribe. That's prophylaxis 1. Prophylaxis 2 are the base limits. The most they can contribute to the political party is $44,000.
Can I stop you there? Do you think those limits are constitutional? I assume you think they're not constitutional.
Your Honor.
And that in a future case, kind of how this march has proceeded, that you would argue those limits on parties are not constitutional, so as, to get to my first point, to equalize the strength of political parties and outside groups. That's the real source of the disadvantage, right? You can give huge money to the outside group, but you can't give huge money to the party, and so the parties are very much weakened compared to the outside groups. So to cite that as a prophylaxis, I'm not sure 5 years from now, 3 years from now, how that will look.
Well, Your Honor, what I can say is that we are not here challenging that limit. And under Buckley and the long-standing notion,
you think it's constitutional?
Your Honor, I don't have a position on whether it's constitutional or not. I'm willing to assume, for the sake of argument here, that it's constitutional, but it's still only the second of the two.
You're not going to want that cited back to you in a couple of years. Assume for the sake of argument. Okay, that's all right.
The third thing I'd point to after that is the earmarking rule, and it's actually a crime to violate the federal earmarking rules. The fourth thing I'd cite to you are the disclosure requirements, which allow the FEC and the public to follow the money to figure out if something nefarious is going on. The fifth, of course, is the bribery laws, which make all of this a crime. So this isn't an example of one prophylaxis, but it's 5, probably I could come up with others, prophylaxes on top of one another. And if you kind of put it all together, suppose that a donor does want to bribe a particular candidate by going through the party in coordinated spending. It's got to hope that the party is going to spend that money on behalf of the candidate when the party's got a much broader set of interests. Lots of candidates are running unopposed, or they have very little chance of winning, or they're just generally in safe seats. Parties don't want to spend money on behalf of those candidates. So if I'm trying to submit a bribe to bribe that candidate, it's not likely going to get through to the candidate at the end of the day. And if it does, it's going to be pretty blazingly obvious. Why on earth is the party spending all of this money on behalf of a candidate who's in a safe seat or who's running unopposed? That's when the disclosure requirements kick in. That's when the FEC kicks in. That's when the bribery laws kick in.
I take that happens sometimes. I mean, sometimes it's pretty obvious, though, I think, in the real world, and I think you would acknowledge that, too. But I'll stop there. Thanks.